If you all are ready, you can approach.
With a rubber band.
Are you ready? All right, the court is going to call 2023 CR 5021 and 2022 CR 1748, State of Texas versus Miguel Rangel. Can I have parties announced for the record, please, for the state?
Daniel Escobar for the state of Texas.
Orlando
Defense.
Castañon for defense.
And are you Mr. Miguel Rangel?
Yes, Your Honor.
Counsel, in each of the cause numbers, have you received all of the discovery and did you review that discovery with your client?
Yes, Judge.
And each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Rangel, in each of the cause numbers, I'm showing you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
And cause number 2023 CR 5021, you're charged with the offense of evading arrest or detention in a vehicle. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And cause number 2022 1748, you're charged with the offense in count 2 of possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Do you understand?
Yes, Your Honor.
And each cause number, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
Yes, Your Honor.
Did you understand by entering into plea bargain agreements in each of these cause numbers, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea agreements in each of these cause numbers?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
And each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each of the cause numbers, I'm showing you the plea bargain page. Did you review those pages with your attorney and did you understand them?
Yes, Your Honor.
And each cause number, the state is asking that your punishment be assessed at 8 years in the prison. There are no applications. The cases will run concurrently. They will take in consideration 2023 CR 5660, 2023 CR 5022, 2023 CR 5023. Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
Then in cause number 2023 CR 5021, how do you plead? Guilty, not guilty, or no contest? And in cause number 2022 CR 1748, how do you plead to count 2? Guilty, not guilty, or no contest?
No contest.
State and each cause number, do you have any evidence to support the defendant's plea?
Your Honor, in each cause number, the state offers State Exhibit 1 and all attachments.
We have no objections.
And each cause number, Mr. Rangel, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them and did you sign them in all the appropriate places?
Yes, Your Honor.
And each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. And each cause number, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
And cause number 2023 CR 5021, the court will sentence you to 8 years in the prison. Give you credit for any time served. This will run concurrent with 2022 CR 1748. Taking consideration 2023 CR 5660, 5022, 5023, 5687, and County Court cause number 654275. Is there anything else with regards to sentencing in that cause number?
No, Judge.
Cause number 2022 CR 1748. The court will sentence you to 8 years in the prison. Give you credit for any time served. This will run concurrent with 2023 CR 5021, taking consideration 2023 CR 5660, 5022, 5023, 5687, and County Court Cause number 654275. Is there anything else with regards to sentencing in that cause number?
No, Judge.
And because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
And counsel, I will give you the dismissals. All right, we can go off the record. Mr. Rangel. Let me just tell you about your actions that day. Because of what you did, that person who pulled over, who was trying to help the person who really didn't need any help with the flat tire, because it appears that you all were working together. That person now will probably never stop just to help someone else who may truly be in need. And that makes for a snowball effect. So there may be somebody pulled over to the side of the road. It may be somebody who's pregnant in dire straits, and that person is going to pass them up and say, well, the last time I tried to help somebody, they were actually conning me. You're going to have to start making better decisions, and you need to ask yourself, was stealing a vehicle worth 8 years of your life? You understand? All right, good luck to you.
Bill, these are your copies real quick.
All right, could I see the parties on Kevin Owens, please?
Judge, I have to note that my client is under the current opinion that he's been instructed to not communicate via third party or directly.
Oh, just 1 second. Let me call the case and then we'll. All right, court is calling 2021 CR 1906, State of Texas versus Kevin Owens. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Orlando Castano for defense.
And are you Kevin Owens?
And so that is what I'd like to address is he is of the opinion, because the proceedings are live streamed,
Mhm.
that any statements he makes is him communicating to whoever.
All right,
And so
thank
he was asking for an order that he be allowed to speak while in court.
I mean, I'm asking you a question, so obviously I want you to speak. Are you Kevin Owens? That's either yes or no.
Yes.
All right, so there has been a motion to withdraw attorney.
Yes, Judge.
All right,
And so I also followed the motion to modify conditions. I'm not sure whether you want to address both.
well, let's address the motion to withdraw first, and then we'll see if we get to the other motion.
I've represented Mr. Owens now for just over 2 weeks. We met last week at my office. And during the duration of our my representation, he and I have had differences in regards to how to proceed on this case. There has been, I believe, a strong difference in opinion on how to proceed. He's asked me to do things that I do not agree with. And in that disagreement, because I've not wanted to move forward the way he's asked me to, he's notified me in writing that I was fired. And so he asked me to file a motion to withdraw, and I've done so. I believe at this point, though, that our disagreements are fundamental and that I cannot ethically represent him.
All right, so Mr. Castagnone, I believe you're the third attorney on this case.
I believe I'm the second.
The second. All right, I thought there was someone before Miss Gay.
Ms. Gay, and I believe she was the first lawyer on this.
All right, can you look in the record and see if Miss Gay was the first attorney on this case, please? All right. So this is scheduled for trial October 9th. So your motion to withdraw will be denied. Mr. Owens, if you wish to hire another attorney, you're more than welcome to do so. But whoever that attorney is, they're going to need to be ready for jury trial on October 9th. So
Judge, I don't believe I can ethically, again, as I stated, represent Mr. Owens. And I believe that eventually he not wanting my representation, I believe that this is an issue that is an appealable issue. And I don't believe that I can ethically be his attorney at this point.
All right, motion is denied. The next motion is the motion to modify or delete bond conditions.
Yes, Judge.
All right. Counsel, you want to address that?
Yes, Judge. We've asked, my client is indigent, as you know, that I have been appointed on this case. And previously, I believe Ms. Gay was appointed. I'm not certain of that, but I do know that I have been assigned to represent him. He's asking that his GPS fees be waived because he is indigent. I did not put this in the motion. I forgot to add this, but I did speak to the state in regards to his request. He also would like to have drug test fees waived because he is indigent. And so he has recently had to provide a drug test, and it cost him $10, and he's struggling to have money. He's not been able to work. The other issue he's asked me to address is that he'd be allowed to have tracking only. And the facts of this case do not demonstrate that he has gone to any individual's business, home. These were all through electronic communications. And so I do not believe that GPS is necessarily something that's going to prevent any of those types of issues. So we'd ask that tracking be allowed. He's been having a difficult time finding employment. And he did recently find employment with Toyota, but his understanding is that he has to have the employer come in and testify as to his employment. And because of that, that was prohibitive, and he was not able to maintain that employment. And so, that condition, if the court does not wish to allow him tracking only, we'd ask that that be removed, or in lieu of in-person testimony, that there be some type of ability for an email with company letterhead or something acknowledging that he has been employed. Because he is indigent, he has not been able to retain his own attorney. He can't afford GPS fees. And so it's important that he gets out there and begin working.
All right. State.
Your Honor, I think that the court wants to waive the fees. I think that's reasonable. With the GPS, we would ask that you keep the GPS the way it is with full house arrest. Code says that the court can make reasonable conditions as part of bail. And I think that's a reasonable condition. We think the defendant has been doing well because of the GPS, not in spite of it. So we would ask that you keep that in place. The part about the order, the defendant being able to speak in court, I think you addressed that in the last motion, but I mean, we don't have any objection to that. We want to be able to speak while he's in court. And any conditions with employment, I think that's up to you, Judge. So we don't have an opinion there.
All right. Is there anything you wish to add, counsel?
No, Judge.
All right. With regards to his speaking in court, I mean, that's very broad. You don't want somebody to be inappropriate. However, if there's something he wishes to say,
I believe
can't
his concern is also just acknowledging his presence, Judge. So any speech that he made or makes, he was under the belief that he would be in violation of the court order.
no, I never put a court order in place that he could not talk. But I will say this, I can't give you any legal advice, but I know that anyone who had a criminal case or any type of legal case would perhaps want to speak to their attorney before they decided to speak to the court, but that's completely up to your relationship with your attorney. So I think that's overly broad. So I'm not going to rule on that.
I think he was looking for an order just allowing him to address the court. Should he be asked to speak, asked to announce it present? And if he were to testify, that he'd be allowed to testify.
Yes, of course he can. If he decides to testify, then you're welcome to testify. That's within your purview to make a decision. A client in criminal court has certain rights. One is whether they enter a plea or not, whether they go to the court or the jury for punishment, whether or not they decide to testify or not testify. So I really don't understand the defendant being permitted to speak while in court, that request, but I'm telling you, you can speak in court. With regards to the GPS fees, I'll ask that those be waived or deferred. With regards to employment, counsel, if the issue with the employers testifying is because there was no documentation that was being brought to the court when there was a issue of whether or not he had employment, and the court wanted to know what employment he had, what the hours were, and what would the job entail. Because of the nature of what he's charged with, the court didn't think it would be prudent for him to have employment where he's not at a stationary place.
And I understand that, Judge. I believe that the facts of the case do not warrant restriction of his movement because he's not been, I believe, accused. It's not alleged that he's been traveling to or anybody's residence or business. And so, I mean, it seems to be just a bit of an overreach in regards to restricting his ability to find employment.
All right, so I'm going to order that he has to provide proof of employment, and that includes his work schedule.
And so just to clarify, when you say provide proof, would an email from the letter or a letter from the employment with letterhead, would that be sufficient proof?
But it'd have to have what his work schedule is. Yes, and counsel, I'll depend on you as an officer of the court to verify that that is
Absolutely.
correct. All right.
Just so I'm 100% clear that you're not requiring that his employer come in and testify to such.
No.
Okay.
And then with regards to him being permitted to speak while in court, sure, he can speak while in court. With regards to tracking only, that's denied.
And I did list it in there, but there's space for it if the court approves permission to waive any drug testing fees. I don't know if the court has the ability to do that, but
I will waive drug testing fees. All right, is there anything else with regards to this motion?
right. And so he has been including me on emails. He does have household duties such as going to HEB. And so, he would like to be able to go at least once a week to get groceries. He did ask for permission to go to the post office. And so I believe he would like to at least be able to go because he's been having them delivered, which is a fee.
Mhm.
And it costs additional monies to have those groceries delivered. And so he would like to at least be able to go to HEB and pick them up.
All right, that will be denied. Is there anything else?
Good judge.
All right, so you all will be back here on October 9th for jury trial. And we'll go from there. Is there anything else?
No, Your Honor.
No judge.
All right, do you need a reset form, Mr. Owens? I'm sorry?
Do you want a reset form to show that we're going to be here on October 9th or?
Yes. All right, Ms. Ferguson, if you can give them a reset form for October 9th. All right, who's the prosecutor?
I am judge.
Have you all both had a chance to review the PSI report? All right. Court is calling 2023 CR 3852 State of Texas versus Kadan Johnson. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Louis Martinez on behalf of Ms. Johnson.
And are you Ms. Johnson?
Yes, yes.
All right, we're here for sentencing. You entered a plea on July 18th. I don't know why this has lasted so long. I think they were running behind on PSI reports because I see it, she pled in July
Mhm.
and it's been set for today. So I guess that's the length of time it took. You entered a plea to DWI third. According to the plea, punishment is to be assessed at 6 years in the prison. The state recommends community supervision. I ordered her to be considered for felony drug court. What were the results of that? Okay,
Can I speak?
just a moment.
Honor, she meets the criteria. However, since she has not been granted probation, we, case must be resentenced to final disposition and ability drug court in that capacity. Also, I believe she's in Kendall County, so that may have some effect on the felony drug.
She is, they're not going to accept her. All right, thank you. All right, state anything you wish to say?
Your Honor, we're asking you to follow the agreement and follow the recommendations of probation. In the TAP evaluation, they're recommending the state ISF followed by ISP supervision for aftercare treatment. And I think that I just don't want to set her up for failure, Judge. So something structured like that, I think would be helpful for her to maintain sobriety. There was a wreck in this case. So I just wanted to draw your attention to that on page 3. So I think the state ISF, something structured like that would benefit the defendant and benefit the public also. Just
All right, defense.
So, Judge. First of all, we asked the court just to accept a plea bargain on probation. It looks like the court is okay with that. One of the reasons we didn't just proceed to sentencing was I wanted to see the TAP recommendation before we approached the judge for her treatment plan, because obviously we were going to be in need of a treatment plan. Ms. Johnson's previous DWI to this was in 2007. She maintained sobriety for a long time. But she fell off the wagon when she lost a child. And obviously, I mean, that's the greatest fear of any mother is losing a child. She began drinking again. She had this issue. She was arrested in December of 22. And I mean, this is obviously a wake-up call. And she began working towards regaining her sobriety. She was having issues with that. So in March of 23, she went to La Hacienda for inpatient treatment. She did well there. She has followed that up by being in meetings 3 to 5 times a week. She's doing very well right now in maintaining the sobriety. We haven't had any issues with her since she went voluntarily and placed herself in inpatient.
In a sober house for 3 months.
Right, and then followed it up with a sober house for 3 months. So, I mean, Ms. Johnson is a nurse. She understands her needs. And I think that she's done a very good job of being honest with herself and honest with the court as is reflected in the PSI and the TAP. And I believe that she has worked very hard in the time that she's been on bond to put herself in a good position. So given that she's doing so well right now, I'm asking the court to kind of give her something that's structured towards that. I'm asking the court to maybe assess an intensive outpatient followed by aftercare. If we want to put her on an intensive supervision plan, I think that would be just fine. And really, Ms. Johnson will do whatever the court needs her to do or requires her to do. But the idea of putting her in ISF is going to take her out of the routine that she's in right now. And I appreciate that the state wants to make sure we don't set her up for failure. But she's done a very good job of addressing her needs already and putting herself into a good plan and is doing well. And so we ask the court to recognize that and to continue with something that is along those lines.
Okay. And with regards to any restitution?
That's taken care of through insurance, Judge.
Okay. So has that already been settled?
It's my understanding, yes, Judge.
All right, because I'm reading when I read the PSI report, it said it was pending.
My understanding is that's been settled. But neither of them, her insurance company was taking care of that.
All right, Ms. Johnson, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Kaylin Johnson.
All right, so what are you doing to maintain your sobriety?
I'm right now on the 9th step. I'm working with a sponsor. I brought my book showing I'm going to about 4 meetings a week, 3 to 6. And so it's averaging 4. I brought a letter from my sponsor also. I'm just I did enter into treatment at La Hacienda. And then one of the doctors there told us that so many people relapse after they get out because something about the prefrontal cortex. And he said, you have 90 days before your brain can do without that substance. And so I lived with 7 other women in the sober house for 3 months.
Okay, and you
Oh,
say you
and
have a
I
letter?
monitor my breathalyzer twice a day.
Okay, and you say you have a letter?
Yes.
Any objection to the court seeing the letter?
None, Judge.
No objection.
And then, like she said, she's been blowing twice a day since she got out of La Hacienda, and we haven't had any issues with her.
Just stuff in here. May I approach?
Yes.
Okay. Sponsor the other day. I just started keeping track of one and best dates, but I've been going over the meetings and digging for the letter.
Okay.
She also, I had a bunch of letters written to my big food soft service person.
Mhm.
And I didn't know if we were allowed to see those or not, but this
Yes.
documentations of how I can do it. Here it is.
Here's this back.
February 28th. And I just realized.
Okay.
I'm on the right track.
Okay. All right. Any other questions?
Oh, Your Honor.
Any
No, Judge.
questions? Okay. This is what the court is going to do. I'm going to sentence you to 6 years in the prison, suspended and probated for 4 years. There's a $2,000 fine that will be probated. There's to be restitution, if any, to RIQU and counsel if you provide documentation that restitution has already been paid, provided to probation. There's to be the DWI panel, DWI education course, 2 years driver's license suspension, 150 hours of community service restitution. There's to be NA or AA meetings 4 times per week. Intensive outpatient treatment with probation. In lieu of the 10 days. Has she already served 10 days in the Bear County Jail or no?
No, Judge.
All right, in lieu of the 10 days in the Bear County Jail, there's going to be GPS tracking
That's on the car already.
for 30 days.
It's already, I have the camera and the GPS with my.
They'll just let probation know.
Probation control.
So that will be for 30 days in lieu of the 10 days in jail. Proof of employment. Are you employed?
I'm retired. I'm almost 67.
All right, proof of employment or retirement within 30 days. There should be no employment as a home health care provider or with minors. There should be regular reporting by Zoom or in person. Regular UAs, make sure there's testing for alcohol as well. And are you asking for a transfer?
I don't think so, Judge.
Okay. Then there'll be field visits. One time every 3 months. Random until further notice. Probation, is there anything else she needs? Yes.
You said the restitution was to Did you want her to do the DWI education or the DWI intervention?
Which do you recommend? All right, then DWI intervention.
And then, as far as an ignition interlock is concerned,
Thank you. Ignition interlock for half the term.
for Maine, Kendall County,
Council is saying that they are not requesting a transfer to Kendall County.
My home is in Bear County.
okay.
Okay. All right.
Nothing else, Your Honor.
Yeah.
All right. Is there anything else from either side?
No, Judge.
Is there anything else you need from the court?
Oh, man.
All right.
Judge, she did the DWI ed and the victim impact panel.
Yeah,
up
I've
front.
taken them both.
So just whatever you're requiring her to do, if she's done that already, we'll just ask that she gets credit.
Yes, just turn that information into probation.
Education. If the intervention is more extensive. than
Yes.
education.
Oh, we understand that. She'll do that again.
All right. Oh, excuse me.
Thank-
No, we're not done. I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
what we did.
Yes, ma'am.
Yes. Your Honor.
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. I see that you've made steps to correct behavior. But as I always tell everybody, at the end of the day, if you're drinking and driving, you could potentially end up killing someone. You understand?
Yes, I'm so grateful I didn't hurt anybody.
All right, good luck to you.